Members, we turn now to the Shop Trading Hours Amendment Bill. The question is that Part 1 stand part. I think there is a requirement to have a Minister in the chair.
Sorry, I'm just a bit slow.
Yeah. Well,
Mr. Chairman.
Ian Lees-Galloway.
Thank you very much, Mr. Chairman. There is a extensive supplementary order paper in the name of the Minister, Michael Woodhouse, that addresses, I think in total addresses many aspects of Part 1 of the Shop Trading Hours Amendment Bill. It's a complex supplementary order paper that addresses a number of different matters. I'm aware that members have a range of, or have views on different clauses and do not universally support or oppose all aspects of the Minister's supplementary order paper. So I intend to begin working my way through the changes proposed by the Minister and address in particular those that we are opposed to, but also to point out where members will be in support. I want to make it clear that that this is an SOP that has a number of different aspects to it, and people have views both for and against different parts of it. The aspect that caused members on the Select Committee the most concern was the shift from councils being required to implement a bylaw to regulate Easter Sunday shop trading to a shift to a policy. Now, the thinking behind this is understandable. Councils came to the Select Committee and said and told us that they would much prefer the government to take responsibility for this issue and to legislate so that we had one rule across all councils, and that by passing this responsibility on to councils, the government was actually generating a lot of cost for councils, because with a bylaw comes the requirement to consult and the requirement to draft the bylaw and all those matters. So there's a lot of staffing resource, a lot of time would be dedicated to essentially doing the government's work for them. And in response to that, understandably, the government has proposed through the Minister's SOP to relax the requirements somewhat by shifting from a bylaw to a policy. And they're doing this in the name of reducing costs for councils. Now, that is problematic on a number of fronts. First of all, it doesn't actually reduce costs for councils all that much. They still have to go through consultative processes, and they still have to review their policy. And in fact, what a number of the amendments proposed by the Minister actually do is to sort of have a policy plus approach. So it's somewhere between a bylaw and a policy. So councils will be required to have a local shop trading policy, but will have to have levels of consultation and review that are normally required under a bylaw. And so actually councils will have to do as much work and bear as much cost by shifting to a policy as they would have had to do under a bylaw anyway. However, it does reduce somewhat the public's ability to have their say, and I know my colleague David Cunliffe, who chairs the Regulations Review Committee, will traverse aspects of this change which arguably create a Henry VIII situation where councils will, through a policy-making process, be able, and through regulation, be able to overrule the primary legislation. And so it's problematic on one hand in that it creates those difficulties in the legislation, but also that it doesn't actually achieve, Mr. Chairman, it doesn't actually achieve the intention which is to reduce the costs placed on council. And councils were quite clear about this, that they don't actually want this responsibility at all. And this is sort of a halfway house approach from the government to attempt to address that. And so I will, and I know other members are planning to oppose those aspects of the Minister's supplementary order paper. There are aspects of the Minister's supplementary order paper that I do support, and that is those that refer to basically workers' rights. So whilst overall I'm opposed to the approach that removes one of those family and community days where people can be guaranteed a day off work, in the event that this House does decide to pass this legislation, and certainly the vote at second reading suggests that the House does intend to pass this legislation, then there is some mitigation offered by some of the amendments that the Minister proposes, and in the name of making a bad piece of legislation slightly better, I'm interested in supporting that. So subpart 2 refers to shop employee rights, and there are some aspects here. So 5H refers to the provision requiring a shop employee to work or be available to work on Sunday being unenforceable. So the original legislation as drafted said that a worker cannot be required to work. Of course, earlier this year we debated the issue of availability clauses and being required to be available. And so 5H actually adds in there the situation where a worker might ordinarily be required to be available for work. That this legislation, with this amendment, they would not be able to be required to be available for work, and that is an improvement. It's as I say, fundamentally bad legislation, anti-worker legislation, but that change that makes it clear that an employer cannot require a worker to be available for work on Easter Sunday is an improvement. 5J refers to an employer's obligation to notify the shop employee of their right to refuse work on Easter Sunday. Now this is important, that a lot of workers are not aware of what their rights are, and it's extremely important that workers are made aware that they have the right to refuse work on Easter Sunday. And the amendment there refers to the period of time in which the employer must make the worker aware. And what we've done is what the Minister has done with this amendment is to create a window of time. So previously the legislation said it must be at least 4 weeks prior to the Easter Sunday. Now that could have been 4 weeks to forever. So they could have been able to give them a warning 364 days beforehand that they needed to be aware. This creates a window of time. So between 4 and 8 weeks before Easter Sunday, the employer, if this amendment passes, will be required to inform the employee that they have the right to refuse work. And that's important, that the employee is made aware of that right, and that they're made aware of it at a time that is appropriate, where they'll be making their decisions about whether or not they want to spend time with their family, as they're currently able to do under the current law, or whether they will prefer to go into work. Now, the truth is that there will be a lot of pressure applied to workers in this situation, and workers will feel coerced into working, regardless of what their rights are, regardless of the fact they have the right to refuse work. The truth is that a lot of the employees that this legislation is going to apply to are on minimum wage or close to. They have insecure hours, and they know that exercising their right to refuse to work on Easter Sunday could very well lead to not being able to pick up the hours that they want to ordinarily. So although the right is there, and although this is an improvement in terms of how employees will be informed of their right, it's still not a massive improvement.
The question is, Claire Curran.
Mr. Chair,